Today we're live from Houston, Texas at Reddy & Newman PC, where we provide complex immigration with simple results. My name is Emily Newman. I'm a partner with Reddy & Newman PC. Our firm has been around since 1997, practicing exclusively in the area of employment-based immigration. I'm also here with my partner, Rahul Reddy.
Hi, this is Rahul Reddy. We formed our organization in 1997. We do exclusively business immigration. Today we are here live. The way we present at Reddy & Newman PC is practical questions that as a immigration client that you get it. That's the questions we are going to ask. That's a question we're going to answer it. Please ask any questions that you have on the Facebook. We'll try to cover as much as possible. I will try to pose questions that are more practical, that we hear every day from our clients, and also on the blogs that we have, the questions that we raise. And also with experience of 20 plus years in immigration, we know what questions are going to arise. And never forget that before I became an immigration lawyer, I was a client to an immigration lawyer. So I know the things what you guys go through. Emily?
All right, well, we're going to start off with kind of some of the hot topics that have been happening in immigration. Feel free to ask your questions while we go through that, and we'll get to as many as we can. If you would like more detailed information, or if we're not able to get to your question, you can always set up a consultation with one of us or any of our other attorneys by going to rnlawgroup.com and scheduling a consultation there. So the big news on Friday was the 180-degree reverse about face of USCIS on STEM OPT extensions and being able to work at a third-party site. So what exactly changed on Friday?
Well, the USCIS in January, somewhere between January and March, quietly updated their website, contradicting the previous standing they had, which they had from 2016, that a STEM extension person who is working at a third party cannot work at a third party site. They've clearly defined they cannot work at a third party site. Now in the 2016 though, in the website that they had, they did indicated in the PowerPoint presentation that a STEM extension person, if there is a proper control and authority and training by the employee can be placed at a third-party location. But between January and March of 2018, they changed their opinion. However, I don't know whether it's due to the litigation of the IT serve organization, probably the force of the companies. They updated their website saying that now it's okay for the STEM extension person to work at a third-party site. Of course, there must be control by the employer. The training part which the employer is supposed to give the employee can never be delegated to the client, but a third-party placement per se is allowed at this point of time.
All right, so let's go right into one of our first questions from Surya. This is a very common question right now. So what if someone during their master's program, this is their first master's in the United States, maybe after their second year, for one summer they get an internship and are approved for CPT, and they do a 3-month internship and maybe another 3-month internship next summer. So now they've used 6 months of CPT time. When they apply for their OPT after graduation, are they only eligible for 6 months now because they've used CPT?
No. If the CPT period is less than 1 year, they are still eligible for the OPT for a period of 1 year. Please note that this particular gentleman who is asking the question, he has completed his first year and got the CPT. He's completed his 2 semesters and got the CPT. So if the CPT has been granted in a fashion where this gentleman has, I don't see any trouble in him getting the OPT though. Where I'm concerned, Emily, is that those universities that are not even conducting any classes and they are granting the CPTs, what do you think about them in light of what this gentleman who completed his 2 semesters and got the CPT?
Right, yeah, I definitely think not all schools are created the same. There are some schools that seem to cater specifically towards international students, especially those that hadn't made it into the lottery after they've already done one of their a master's program here. And I think that there are, they're I don't know, stretching what CPT is supposed to be. And it might get to a point where USCIS strikes back against that. I mean, we are seeing requests for evidence a lot on CPT, second CPT, or people who've done OPT, then CPT at the same degree level. There's 5 different types of RFEs we're seeing on these particular programs, and they do seem to be more scrutinized. I generally am not a fan of them and suggest avoiding them. But going back to a serious situation where you have only used 6 months while you were in your first master's program during your summer, and then you do OPT afterwards, shouldn't be any issues there. I will just warn you that people are receiving requests for evidence on that. We've received a couple in our office where USCIS is claiming that because you did 6 months of CPT, now you only get 6 months of OPT. Those have been successfully responded to. So
you mean to say that their OPT has been granted properly for the 12 months?
Okay. Right. Yeah. So you may be questioned on it, but you should, at least as of right now, still be successful on that.
And don't forget that on Thursday at 5 o'clock, we're going to cover the CPTs, just CPTs alone, not clubbing with the other things. So if you can tune in, that would be so nice. Emily, what's going on in the H4 EAD? Is H4 EAD still there? Well, the administration said that they might take the H4 EAD off. They might put a restriction off. They said they're going to they're going to issue the proposed regulations in June of 2018. Now we are almost end of August of 2018. Are there any proposed regulations at this point of time? Can the people who are eligible for H4 EAD, can they apply for the H4 EAD? Can they extend their H4 EAD? And if by any chance, when the H4 EAD regulations, proposed regulations are going to come, what are the effects it's going to be?
Yeah, so as of right now, still nothing has been proposed. Like you said, we should have seen something in June in the Federal Register. It still has not been submitted to the OMB for pre-approval to actually propose the regulation, and that process usually takes at least a month. So we're now looking into September is the earliest we might see something. Now, it's totally normal that a regulatory process gets delayed. It happens all the time. So I'm not going to read anything into that and assume maybe they're changing their mind. Unfortunately, I don't think that's the plan. I think that they're gathering information or coming up with arguments as to why they should be able to rescind the H4 EAD, and it's just taking longer than they expected because I'm pretty sure they're expecting a court challenge. Now, while all of this is going on, you can still file the H4 EAD, even if it's a brand new one. You can still get the renewal. No issues in that whatsoever. Even if the proposal is actually published while it's pending, which is going to be a months-long process, you can still file your H4 EAD, still get renewals, no issues there. So at some point in the future, when a final rule is published, it will list an effective start date, and from that effective start date, they will then tell us this is the point where you can no longer file or
fresh applications and maybe not renewals.
Right. So we don't know exactly what they're going to do for those who already have it. Are they going to allow you to continue renewing, or will that be your last renewal? We don't expect that they're just going to terminate valid existing H4 EADs at the time that regulation comes in. It's all speculation at this point, but we should have plenty of advance notice.
Emily, Naga has this question from live, is that if the H4 EAD is expired and he filed an extension, can he work after the extension is, after the current EAD is expired?
Yeah, that is a really good question, and it's very confusing because different types of EADs have different rules. Specifically for the H4 EAD, no, you cannot work while an extension is pending if your current EAD is expired. Compare that to OPT, where when you file your STEM extension, you can work for up to 180 days while you're waiting. Compare that to the 485 EADs. You can work 180 days. But specifically for H4 EAD, you cannot. The reason for that is because you have not yet been approved for your H4 potentially. So they need to verify your underlying status before they will also allow you to work. But H4s need to file well in advance. File with the H-1B and premium processing when you can. They are usually approving them all together in the 2-week period. Not guaranteed, but that is one way to speed it up. If the H-4 is filed separately and you have to file an H-4 plus an EAD, it's going to take over a year. Processing times for the I-539 are ridiculously long.
Unless it's filed with H-1B, you'll have trouble.
Yeah.
Emily, one question Rajesh has is that, it's Raj Shekhar. He has is that, are you confirming that the STEM extension person can work at third-party location? Or is it any conditions attached to that?
Yeah, it is not a blanket approval for every single third-party placement. Only those situations where the employer-employee relationship is being maintained between the student and the employer, the actual company that placed you there, and the training obligations are being met by the actual employer, not the client or the third-party work site. So those two things have to be met. Those that have requests for evidence on this issue in the H-1B, those are the standards you're going to have to meet. You have to prove that even though you're at that other company's work site, you have an employer-employee relationship with your actual employer, and that actual employer is the one that's giving you the training and maintaining that relationship.
So even when the RFE comes in, you still need to be able to prove about all these things. It's not going to be blanket. You're working at third-party side. You're not just blanket safely. You need to do the documentation, all those things.
Sridharan has a question about processing times. So how long is it taking to get an H-1 transfer processed in regular processing right now?
Why regular processing? Well, regular processing is taking 8 months. And if there is an RFE, and the lawyers are taking their own time to respond to the RFE because it needs to be responded properly, otherwise there will be denial. And after they respond, it takes about 4 to 6 months. So the total period of time that's taking can be anywhere between 6 months to about 1.5 years. And that's one of the things. Why are these people not filing premium processing? Let me tell you some of the rumors, and please clarify if there is any truth to it, Emily. If you file in premium processing, is it absolutely sure you're going to get an RFE or a denial just because you filed in premium processing?
Definitely not. We see plenty of cases that receive an approval directly without RFE in premium processing.
Is there a higher chance for getting an RFE in premium processing?
No, that has not been our experience. Our experience are the two processes are very similar except for the speed. So I don't think that that's true, that there's a higher chance of RFE or a higher chance of denial just because you're filing in premium.
I may want to disagree with you a little bit, Emily. On the premium processing, I think so. On the contrary, there is a little bit more higher chance of getting the approval because the request for review is there, and they do respond to the request to review if there is a clear error in premium processing. And
even in the case where it got denied.
Right, in the case it's get denied. So if it is a regular processing, the review might take 8 months. They will lose a job and they cannot work while the review is going on. So I think so that premium processing has a slight higher chance of approval in contrary to a lot of what people think. Well, that brings to a couple of other rumors that are flying around, Emily. Rumor mills are flying now. Somebody is saying that you can't work right now on a receipt notice for an amendment. You can't work on a receipt notice if the I-94 expires and receipt notice is there. You can't file for on a receipt notice when the company has filed for a transfer on the H-1B from one H-1B. Is that true that you can't work on the receipt notices anymore? Is there a change?
No, it's definitely not true. The law on that has not changed. H-1B portability still exists, which says that as long as you timely file a transfer Once it's filed, you can join the new employer. You don't have to wait for the approval. Same with an amendment under the matter of SIMEO guidance. As soon as the amendment is filed, you can start working in the new work location. You don't have to wait for the approval there. Now, I think probably where people are getting the misinformation on this is because of the NTA memo, where if at the time you finally get the decision on your transfer or your extension,
if your
I-94 is expired at that point, according to the NTA memo, which is currently on hold, but if that comes into play, you could be put in deportation proceedings. That is true. So there is some risk involved in filing an extension or a transfer and your I-94 expires while it's pending. So because of that, that's why we recommend premium processing. It's why we recommend filing early so that you never get into that situation. So yes, you can still file transfers and start working on the receipt. You can still file extensions and continue working based on the pending extension. But you do need to be aware of the timing of that, and again, premium processing is the way to go, I think.
And as Emily has pointed out, that immigration lawyers generally recommend people to have the I-94 validity. There are many reasons why, as Emily pointed out, is that you need to do premium processing. Is that if you get a denial, either for the transfer or for an extension or for an amendment, while you have the I-94 valid, you don't start accruing the unlawful presence. That's the number one thing why you need to get the result ASAP before the I-94 expires. Don't delay, file the premium processing. There are many options that you would have if you have the I-94 validity. Now, if the I-94 validity has expired and you get the denial in either the extension amendment or amendment plus extension or the transfer, your choices will be very limited. So we strongly recommend that you get the results within the I-94 validity.
Srini has a good question. In the event, say, an I-539 H-4 application has been filed or an H-4 EAD has been filed, and for some reason the receipt notice never arrives, is there a way to find out what the receipt number is?
Simple. One thing is that you must have sent a check to the USCIS, go to the bank, get the front and back copy of the check. At the back copy of it, you can read it very, you probably, for an older guy like me, I need to use the magnifying glass to look into it to find the file number, though. You can get the file number from there. And then normally I double verify it if the file number belongs to that guy because of my eyesight. I go to the USCIS website, check if the receipt number says it's I-539 or not. So that's one easy way of identifying the receipt number. Any other ways, Emily?
No, I think that's the main one. If it's your personal case, so you could call customer service and they could try to locate it for you, and they might give it to you over the phone. That's probably a bigger headache than just getting it off the back of the check. In either event, once you have the number, you may want to consider going onto the USCIS website and putting in a service request for that missing notice, and see if they will reissue it to you because it got lost in the mail. Sometimes they will, sometimes they won't, but even if they don't, they'll send you a letter or a response to that service request saying that here's your receipt number, we're not going to send you a receipt notice because it got lost in the mail and it would serve no purpose, but at least you have a document that shows that you filed it. So that's one thing you can do. Another very common question we're getting right now for those that are on the cap gap. So if you've filed your change of status from F1 to H1, and while it's pending over the summer, your OPT expired, you can continue working on the cap gap. But what happens if the H1B is still pending past October 1st?
They have to cease working after September 30th. You cannot work on a cap gap after September 30th. You have to cease working. Now, the previous administration, without taking into consideration the premium processing, though, they used to expedite any case which is under cap gap, and they used to give very prioritization in adjudicating the cases by September 30th so that the individual can make a choices. I don't think so. This administration is doing that. So, Emily, that brings another point on that. The payment processing has been suspended until what time, and when do you expect that? Especially the cap gap people, they're not getting the decision, and then it's October 1st, they have to stop working now. Is the premium processing getting back again, or is it not, or what's going on the premium processing?
Yeah, we don't have any updates or new information on that, but I did go back and re-verify when they made the announcement about premium processing being suspended. They did say in that announcement that it would be until September 10th. So there's a very good chance that it will be coming back on September 10th, but there will be an announcement beforehand. So probably in the next couple of weeks here, we should have updates on that for when cap subject people are able to upgrade to premium processing. For those that, again, are on the cap gap and you stop working on September 30th, the next question becomes, do you have to leave the United States because your cap gap ended? Now, once you hit October 1st, you're then beginning your 60-day grace period. So you can remain in the U.S. during that 60-day grace period, not working, and if your change of status gets approved anytime during those 60 days, you're fine. Beyond those 60 days, in order to remain in the U.S., it is highly recommended that you either change to some other status that you might be eligible for, or re-enroll in school if you're going to continue your studies with a new program. The reason for that is once you pass the 60-day grace period, if your H-1B after that point gets denied, you're immediately out of status. You're immediately accruing unlawful presence from the date of that denial because of the denial. You're kicked out of the civic system. You don't have the chance to enroll at that point. So you have to do it before September or November 29th, I believe, is the end of that 60-day grace period. If your plan, your backup plan, is to continue your studies, get that new I-20 during those 60 days.
Srikanth has this question. Can I file the H4 EAD 120 days, 180 days? What is the actual thing? Even though the website says it's 120 days, when we are filing along with the H-1B transfer, along with the H-1B extension, along with the H-1B amendment in some of the cases, we have never noticed USCIS giving us a problem in adjudicating the H4 EAD. They have kind of ignored that rule of 120 days. They are adjudicating the cases if you're filing along with the H1 and H4. And also, we have filed it many different times when we solely file H4 alone along with the extension way before 180 days also. But their EADs also got approved though. Now, I am telling you as a caution that there is a chance that the USCIS might reverse the decision though. But if they reverse the decision, it's not going to be that harmful. They'll just deny the 765. You can reapply again. It's not going to be, it's not that you're committing any fraud. So I do encourage people to file well in advance. If they are willing to forego the money that they're going to spend, they're going to take the chances of foregoing that. But I have never seen a 765 denial because it was filed before.
So we talked earlier about, while your H4 EAD renewal is pending, if the underlying one expires, can you keep working? And the answer to that is no. So as a follow-up question to that, what if you're in the awful situation where your H4 EAD got approved and there was a problem getting it to you in the mail, it got sent back to USCIS, and now your current EAD is expiring. You got an approval. Does that mean you can actually work?
I would say I would take off the record and speak with a lawyer separately rather than in this open video. I would recommend that you contact, and that means that it's not yes or no. We would like you to speak with a lawyer privately with your own lawyer on that thing, though. You have a different answer for it, Emily? One question this guy has. Mr. Savarna has, Rakesh has this question is, what would be the impact if the HR 392 bill happens for those people who are on H-1B where their I-140 is pending. I recall that you wrote an article in February of 2018. You're part of the person who wrote the article, that for those people who are applying for the green card, if they are Indian nationals, it's going to take 108 years. Everybody laughed at you. Well, they're still laughing at you right now, because now there's a Cato Institute that published more research than probably you have done, and they are now telling you're wrong by 40 years. It's actually 150 years waiting period of time. Can you explain how this HR 392 is going to bring down the timing?
Right. So what created this huge backlog for only people from certain countries is the 7% cap that's in our existing immigration law. So we have a set number of green cards for employment-based immigration available each year. Those are divided up by category, EB1 through EB5, but then they're divided up by country of birth. So anytime a particular country is going to take more than their allotted share, they're capped at 7%. And when you have countries with very large populations that are in the green card process compared to countries with low levels of immigration because their population is low, the question is, should these two countries get the exact same number of green cards? Some say yes, some say no. I think that when we're talking about employment-based immigration, the top priority should be merit, not country of birth. I don't care where you're from. If you're the best person for the job, you should get the job, and you should get the green card first compared to someone who may not be as good. I don't know. That's just my thoughts on it. So HR 392 is the closest thing we have to a merit-based system where you're in line based solely on your category and solely on when you got in line, which makes sense. That's how it should have been. Now, I understand that diversity is also part of the equation. That is one of the pillars of our U.S. immigration system. But I think that for employment-based immigration, that shouldn't be as big of a priority as what we're making it. So by taking off that cap, basically those that are in line first are going to receive the next set of green cards that become available until all the lines even out. Then everyone's going to be on the same playing field. Now with HR 392, I believe there is a transition period.
Yeah, but that's 85% or so is a transition period.
Yeah, so it doesn't mean that only certain countries that have the longest line are going to get green cards for those first couple of years. It does still spread them out and stagger it a little bit so that eventually everybody will be in the same line, which I think ultimately is a smart way to run your immigration system. There are people out there that disagree, that they think that because the rest of the world all of a sudden might have to wait, heaven forbid, 2 or 3 years for their green card.
Unlike 108 years you predicted.
Yeah, so we go for those people going from
busy country,
0-year wait to 2-year wait, heaven forbid, but for people to go from 150-year wait, it's okay. That's just not right. So it was included as an amendment in the DHS spending bill. So it does have a long way to go before it becomes final law. It's got to get into the Senate's bill, and then we've got to get it signed by the president. I think there is a lot of support for it. Unfortunately, there is some talk against it. I think including the USCIS director has tried to sound the alarm bells that this is something that we don't want to do. I think I think our employment-based immigration system should not have anything to do with country of birth.
When I ran the numbers, if the HR 392 bill goes through, in the first year itself, the priority date should jump for the Indian nationals from 2007 or 2009, depending on how you read it, to approximately around 2013. That is the numbers that, based on the numbers that I have calculated it. And probably the next year, which will be 2020 or so, we should be moving into 2016. From then onwards, there should be a waiting period between 2 to 3 years for all nationals if the HR 392 bill goes through.
All right, another question that came up related to I-140. So if I have an approved I-140, now I want to switch companies. At what point does my new company need to start the perm process? Do they have to? Can I just port that I-140 to the new employer? What's the process like?
If the I-140 has been approved, and it's been 180 days the I-140 has been approved, if you move to the company B, the company B never have to file the labor certification. The company B never have to file the I-140 for you. For you to get the H-1B extension, for your spouse to get the H-4 EAD, for you to move from company B to company C, you don't need the company B to file the labor certification I-140. Now, if the law remains as it is, it's very unlikely you're going to get the green card. Seems to be that. Because there are too many people behind the line. They were way behind. They're going to get. There are too many people ahead of you. They're going to get it. So if the things remain as it is, company B never have to file the labor certification, because we are predicting it's going to take about 150 years or 180 years, depending on whom you read. That much long. So you may not need the labor and I-140. But for you to eventually get the green card, and I pray God that HR 392 will be passed. If that passes, you need the company B to file the labor and I-140 application. Only for getting the green card, not for extending the H-1B. You don't need it.
All right, here's a good question. I'm currently on my STEM extension, and my plan is to file a change of status to H4 and EAD. Can I keep working on my STEM extension once I file? And what are some of the issues that I need to be aware of, specifically due to processing times of the H4?
Once you are on STEM extension, yes, and you file for the H4 EAD, you can absolutely work only until your STEM extension expires. And of course, as Emily has pointed out, there are rules and regulations that govern the STEM extension. You need to abide by those rules and regulations for working on the STEM extension. So number one, you cannot work after the STEM extension expires, and you need to abide by the rules and regulations of the STEM extension to continue working on the STEM extension even though you file for the H4 and H4 EAD. Once the H4 EAD is approved, those rules that are there on the STEM extension are not applicable on the H4 EAD. On the H4 EAD, practically no rules. You can flip a burger in McDonald's, or you can be a Microsoft CEO. You can do anything you want, which is legally allowed to.
Yeah, just be aware of the long processing time to get the H4 EAD. Plan on at least a year.
And if by any chance a STEM extension expires and your H4 EAD is not approved, you could stay in this country, not a problem, but you cannot work in that interim period until your H4 EAD is approved.
Here's a question about when an H-1B amendment is required. If I just got a promotion or I got a salary increase, does that automatically require an H-1B amendment, or what do you? When
you say it's a promotion, if it's a material change promotion, Emily, promotions are there for every different range, but if it's a material change, that's a wording that we use. Now, if you are a lawyer, if you're moving from a H-1B lawyer to a labor certification lawyer, you're still an immigration lawyer, but you are going into the managerial level, though, then amendment is absolutely required. You have a different opinion on it?
Yeah, I think the law is that an amendment is required for any material change. So then the question becomes, is that really material to the approval of an H-1B? So if the job duties are basically the same and it's a slight salary increase with no other changes, probably not. If maybe your job title just was changed just because of a company restructuring, probably not. If you received a promotion and now you're doing additional job duties, that may be a different story.
And the salary increase also, if it's an increment like 2%, 3%, which is normally given to the individuals, I think so you don't need an appointment. I'm sorry, you don't need an amendment. But if it's like salary has gone up by 10%, I definitely think so. You definitely need an amendment.
All right. AJ has a good question. If someone had an H-1B before and now they're on H-4 EAD, can they switch back to H-1B? Do they have to go through the lottery?
No. If they already have been counted towards H-1B number, they don't have to go to the lottery system. The other thing, AJ, you can do is that you can actually, on H-4 EAD, if you have not filed an I-140 application, you can still file a labor certification on I-140. Absolutely not a problem. If you move from H-4 to H-1B, which is not subject to cap because you used up, because you have been counted towards previously, they will only give the H-1B for a period which is out of the 6 years, how many ever years you have used up, the remaining period only you will be eligible for the H-1B, unless you have an I-140 approval. So practically, if you are on H-4 EAD, if I were you, I would try to work on getting the I-140 approval, because even if you used up the 6 years, you can get the extension. You probably need that in your pocket at a later time to use that.
Bala has a great question. His friends have been getting phone calls about deportation. Is it something that he can trust?
Those are fake calls. I mean, guys, if you get anything where they're getting phone calls and they're asking you money for the deportation, please, pass it on to us and try to say, don't pay them money. Don't. And they will tell you on the phone, we're going to deport you in the next 2 hours as soon as your phone is hung up. They are all fake calls, guys. And it's easy to determine if they are very fake calls. I actually want to promote these things, that if you find some of those phone numbers, please pass it on to all your friends. You should call them, irritate them. Pretend as if that you're getting scared. But if you're getting a phone call and they're asking you money so that they won't deport, it's 99.9, 100% of the time if they're asking money, it's 100% of the time. 100% of the time, it's a scam call.
Yeah, they can't put you in deportation proceedings by phone call. It has to be in writing. There's very specific requirements on that notice to appear document, and it has to be an actual document that is served. So definitely don't fall for those scams. What do you think about the processing times for CAP cases? Are those accurate right now?
Do you believe in the website which is published by the USCIS? Right. Is that the question you're asking me? No, we don't believe in what the USCIS is saying on the website on the processing time. Right now, we have received RFEs for our adjudications for most of the cases, Emily, about 70-80% of the cases.
I would say, yeah, probably 70%.
70-80. But the rest of the 20 to 30% of the cases, no information at this point of time, no RFE, no approvals for those things. So that's, and they're publishing that it's 4 months. I don't know where they're publishing it. Don't believe in those things.
Have you noticed a delay in green card processing, the 485 processing, because of the new interview requirement for employment-based cases?
Yes, we have seen a significant delays in the 485 processings recently. They have picked up a little bit recently in the past 3-4 months, especially from about June, July of 2018. But before that, I've seen a significant delay. Previously, it was only like 7-8 months, but it's taking sometimes 16 to 17 months in some cases, Emily.
All right, another quick question. If someone is in the U.S. in another status, say F1 or H4 or L1, whatever it is, and they have filed an H-1B in the lottery that is not requesting a change of status, and the H-1B gets approved for consular processing, when do they have to leave the U.S. to go get the stamping done?
So you're telling that they never requested for the change of status. So
Right.
it's change of status is not denied.
Correct.
So change of status has never been applied, so it has never been denied. You have a choice of going to get the stamping at any period of time before your valid visa expires at this point of time. You don't have to hurriedly go and get the stamping. However, that H-1B approval that you have, or whatever visa that has been approved for, you cannot work on that visa. You cannot act on that visa until you go to and get the stamping and come back. Anything that doesn't come with the I-94, it's not valid unless you go outside the country and come back in. But you can continue working or doing whatever you are allowed to do in your current visa. For example, if you are an H4 EAD and then you did not apply for change of status to H-1B, you got the H-1B approval, you can continue working on H4 EAD until the H4 EAD expires, and you can go at any point of time to go for stamping. Emily, the question is that a lot of people ask this question is that my employer is not giving me the I-140 approval. Is there anywhere where I can get it? Do I need the I-140 approval at a later date, or now, or at a later date?
Yeah, you do want some documentation of your I-140 approval so that you can continue to get the H-1B extensions beyond the 6-year limit, even with a new employer, and so that your spouse is eligible for the H-4 EAD. Also, for the ability to retain that priority date in the future with a new employer in their filing for the labor certification and I-140. Now, what can you do if your employer is not providing it? You can file a Freedom of Information Act request. We'll include a link to the website where that can be done. It can be done electronically now, and you can request a copy of information from your I-140 file. Now, USCIS, as far as I'm aware, does not give you a copy of the approval notice itself, but they do give you a copy of the filing, and it generally has a stamp on it stating that it's approved and has the date on it. So that should be more than sufficient to allow you to use that for any future filings you might need.
Hanish asked this question, and I want you to intelligently listen to the question, though, because he says that he got the specialty occupation for RFE. If all the statements and all the proper documentation is submitted, what are the chances for approval? And he's submitting all according to the requirement of the USCIS. Mm-hmm. Can you define what does that mean? All according to the requirement of the USCIS submitted. Is there a mathematical principle? A square plus B square, A plus B whole square is called A square plus B square plus 2AB. Is there a principle that you have with you where you could say to a certainty that you submitted everything as what they requested?
Yeah, unfortunately there isn't. There's no magic formula, no certain number of documents, or no particular documents that can be submitted to guarantee or give you a high chance of success, because it all depends on the job. You know, if an H-1B petition is filed for a janitor and you provide every single document USCIS requests, you're still going to get a denial because a janitor is not a specialty occupation. So it all depends on the job. Does the job truly require at least a bachelor's degree in a specific field? And then what documents do you have to support it? Now, there's a lot of discretion and leeway in there depending on what documents you're providing and how strong the argument is that you're making. So there really is no 100% way to say, I've provided every single document they've requested, now there's no way I'm going to get denied. It's just not true. It really
Can you
is.
give a percentage success rate on a particular case?
No, you can't. I mean, if I knew all the information about a particular filing, I could. But without knowing anything about the job, again, if someone filed for a janitor, I would say the chance of success is 0. But if someone filed for a software engineer, that's not enough information. I need to know what the specific job duties are of that software engineer, what SOC code was selected, what wage level was selected, what is the employer's minimum requirement, did they place any advertisements Have they hired anyone else in that exact position before, and what were their educational requirements? So there's a ton of factors that go into proving specialty occupation. There's 4 different ways to do it. You've got to show the job, the education required is common to the industry, or the job is so unique and special, or show that the employer has a past record of always hiring with that degree requirement. So there's many different ways to prove it. USCIS tends to rely heavily on the Occupational Outlook Handbook, so that's definitely a place to start. But yeah, there's really just no way to answer that question.
Those are some of the things Emily has pointed out legally. And let me tell you, practically, there are other issues also that raise up where we cannot give a certainty what documents or what information. There is a Nebraska Service Center that operates differently than that of California Service Center. And then there's Vermont Service Center that operates, there are 3 different service centers, they operate completely differently. There are situations where we got everything perfect. We got the end client letter describing the job description perfectly. We got the vendor letter. We got the denial saying that the end client letter and vendor letter are reflecting mirror to mirror. That's why we're going to deny the H-1B application. Now, of course, we got that reversed in the supervisory review because it was filed on premium processing, though. There are some situations where the end client letter is a little bit different than that of the vendor letter. Then they denied the H-1B case saying that, well, both letters are telling 2 different stories. We're going to deny the H-1B application. So in the common law countries, though, it's very hard to predict. The officer has a certain discretion, and it's very hard to accurately predict how the things will go on.
All right, I think that about does it for today. Time to wrap it up. Thank you so much for joining us and listening to our live question and answers.
Thank you, guys, and please log in to RN Law Group. If you want to make appointments with Emily, me, or any of our 14 colleagues, you can always make an appointment, RN Law Group. Please subscribe to RN Law Group newsletter, and then Emily's blog is very popular. It's immigrationgirl.com. Any news that pops up with regard to the business immigration, we try to bring it as soon as possible, and we also want to make it as practical as possible. So if you post questions, we will look into those questions to respond to any of those things that we missed out. We will try to answer those things next week. And don't forget that day after tomorrow, that is Thursday, at 5 o'clock, we're going to address exclusively, and that live session is going to be only about CPTs. Nothing else will be covered. All about CPTs, what you need to know, will be covered next Thursday at 5 o'clock live. Thank you guys for coming in.